It's an honor and a pleasure to introduce Professor G. Edward White. Professor White is the David and Mary Harrison Distinguished Professor of Law at the University of Virginia. He's a graduate of Harvard Law School and earned a PhD in history from Yale. Before embarking on his teaching career, he clerked for Chief Justice Earl Warren of the United States Supreme Court. Professor White is one of our country's foremost legal historians. He's published 14 books, including 3 highly respected studies of Oliver Wendell Holmes and an award-winning biography of Chief Justice Warren. The breadth of his scholarship is remarkable. He's written about the Marshall Court and also about the Constitution and the New Deal. In The American Judicial Tradition, Profiles of Leading American Judges, now in its 3rd edition, Professor White offers portraits of all of the great appellate judges from John Marshall through the Rehnquist Court. He's also written about the history of private law. His book, Tort Law in America and Intellectual History, is a classic. His chapter on Justice Cardozo as a torts theorist is fascinating. I recommend it especially to first-year students who are impressed by the rhetorical power of Cardozo's opinions, but at the same time are troubled by a nagging sense that they've been tricked. On top of all these books, and several more that I haven't mentioned, plus dozens of law review articles and book chapters, Professor White has also published a history of baseball, reflecting his lifelong interest in sports. Professor White's topic today is Recovering the Legal History of the Confederacy. Please join me in welcoming the Hendricks Lecturer in Law and History for 2010, Professor G. Edward White.
Thank you. It's nice to be here, and I thought the topic was perhaps somewhat suited to the area. I actually am in the process of completing a first volume of a multi-volume study called Law in American History, and I've gotten myself up to the Civil War period, so I thought that some of the research I did in connection with that would suit a portrait of the legal regime of the Confederacy. There's actually been quite little written recently on that. In fact, the historiography of the Confederacy is itself interesting. The historical community began writing on the Confederacy in the early and mid-20th century, and there is a distinct theme in most of the scholarship of what might be called apologies for the Confederacy and a tendency to restructure issues that led to secession and the Civil War around the kinds of justifications that were advanced by members of the Confederacy after the war ended, emphasizing states' rights, emphasizing the importance of individual liberties rather than slavery. So one of the things I want to do is to try to redress that balance somewhat by taking a look at the contemporary sources at the time of secession and the emergence of the Confederacy. So I'm going to be talking. First be talking about secession itself and why secession occurred, and then I'm going to be turning to some central legal issues for the Confederacy, all of which were related to the war. And I think that was not anticipated by the framers of the Confederacy. One of the interesting features of secession is that most of the advocates of secession did not really anticipate that in seceding from the Union, they were embarking on a major war. They expected that on the whole, the Union government would leave them alone. So let's start with that itself. Why did a group of states in the southern regions of the United States conclude after the election of 1860 that they needed to leave the Union. If you look at their political and social and economic conditions, that would have been regarded as a somewhat unusual gesture. On the whole, the southern states were doing comparatively well, and Americans in general, particularly white male Americans, were doing quite well and had done so throughout the first half of the 19th century. There was a successful severing of America from Great Britain, successful waves of integration. The population was filling up. Agricultural householding had emerged as a ubiquitous and relatively profitable activity in both North and South. The United States had acquired a vast amount of public land beginning with the Louisiana Purchase in the early 19th century. So there were lots of opportunities for immigrants, lots of opportunities to develop independence, have one's own household, and get away from the restrictive status systems of Europe. And so in general, what are the incentives for a group of southern states to give this up? Well, in my view, the secession is a kind of combination of some long-term factors and some immediate factors connected to the politics of the late 1850s and 1860s. First, taking up the longer-term factors. The critical issue for Americans from the 1830s on is the interaction of Western expansion with slavery. Once it is concluded by the generations beginning in 1830s that slavery is not going to die out, but rather has the potential to flourish, and this is because, first, of the invention of the cotton gin and the ability of cotton to emerge as yet another staple crop, replacing tobacco and rice and indigo, all of which had either distinct seasonal problems. You can't grow rice or indigo except in very warm regions, and tobacco exhausts the soil. Cotton emerges as yet another staple crop just at a time when there is a worldwide demand for cotton because of its use in textiles, clothing and other textile uses. And at the same time, the boundaries of the United States expand, and they expand into areas that are suitable for cotton production, suitable for large-scale staple crop agriculture, and therefore suited for slavery. So instead of the framers' generation's expectation that slavery was closely linked to the regional staples of the South, and as those became exhausted, there would be fewer incentives for slave labor, and slavery would eventually die out. It appears that that is not going to be the case. It appears that states like Mississippi and Louisiana and Alabama and Texas are well suited to slavery, and potentially more states west of the Mississippi. The major legal institutions of the United States have all been aware of the tension that the interaction of westward expansion and slavery was producing. They've all made efforts to respond to the problem, and they've all, by the 1850s, by the late 1850s, they've all failed. Congress attempted to confine or diffuse slavery through several measures. First, beginning with the Missouri Compromise in 1820, there are several congressionally structured solutions to slavery which calibrate a very precise balance between slave states and free states within the Union, condition the entrance of additional states from the federal territories on retaining that balance, and eventually in the Compromise of 1850, and then subsequently in the Kansas-Nebraska Act, leaving the question of slavery in the federal territories potentially open. The federal government had outlawed slavery beginning with the Northwest Territory, and the federal government maintained the position that it had the power to do so. But by the Dred Scott decision, even that claim has been contested, and in fact, the majority of the court has held that the federal government may no longer abolish slavery in federal territories because that is an invasion of the due process rights of slaveholders. So, and meanwhile, a succession of executives has acquiesced, whatever their political affiliations, has acquiesced in the what might be called the conventional understanding that slavery is essentially a matter of state law, a positive state law, and that the federal government has no power to overturn state law decisions on the subject. Indeed, one of the issues for the southern states from the 1830s on is the enforcement of a fugitive slave law. Northern states are beginning to pass legislation discouraging their residents from complying with fugitive slave laws where slaves escape from southern into northern states. And one of the features of the Compromise of 1850 is a tightening of the obligations on the part of state officials to cooperate with federal authorities in returning slaves to their owners. So all of this has resulted in a union delicately poised along the slavery issue, facing the prospect of continued westward expansion and the potential movement of slaves and slave owners into the trans-Mississippi West. In that setting, the Republican Party emerges as an anti-slavery party and has one of its platforms in the election of 1860 a defiance of the proposition in Dred Scott that Congress could not outlaw slavery in the federal territories, and a professed determination to do so. In addition, patterns of immigration have rearranged themselves along regional lines, in large part because of slavery. Most European immigrants do not come to the South. They do not come to the South because they feel that they can't compete with slave labor. So they're coming to the North, and they're entering the populations of northern states, northern and midwestern states. And as these states enter the Union, they are increasingly populated with wage earners, and they're increasingly identified as free states. So southern states perceive that the 1860 election, if it results in the triumph of the Republican Party under Lincoln, is the beginning of a shift in influence in Congress, which will eventually result in the South becoming isolated as a region. The nightmarish scenario that the Southerners project is that soon the calibrated balance between slave states and free states in Congress will be disrupted. There will be more free states than slave states. That the federal government will proceed to outlaw slavery in the federal territories, notwithstanding Dred Scott. And therefore the South, as a region practicing slavery, will be ringed with anti-slavery states. And then the next step, they imagine,